Hello there and welcome. My name is James Turner and I am Senior Solicitor at Laurent Law Barristers and Solicitors located in Grey Lynn, Auckland, New Zealand. We are a law firm which specialises in New Zealand immigration law. In this video I'm going to talk about situations in which a person is excluded from New Zealand, meaning they are not eligible to be granted a visa or entry permission to enter or be in New Zealand. The circumstances in which someone might be excluded from New Zealand are usually quite serious. In an earlier video, which is posted on our website, my principal Simon Laurent has presented regarding character waivers, which is a process which has similarities to exclusion issues. For example, a character issue such as a criminal conviction, depending on how serious it is, can give rise to the need for a character waiver, or can also mean that the person is in fact excluded from New Zealand. A common situation in which a person may require a character waiver in order to be granted a temporary or residence visa is where the person has a drink driving conviction. However, more serious criminal convictions can mean a person is excluded from New Zealand. The only way an excluded person can be granted a visa or entry permission is if that person is granted a request for a special direction. The politicians who helped write the law likely believe that serious criminal convictions mean a person's character is so tainted that they should not be granted any visa or entry permission unless the highest level authority is given by way of the grant of a special direction. The full list of circumstances in which a person is excluded from New Zealand is set out in Section 15 of the Immigration Act 2009. These are 1. Any person who at any time has been sentenced to a term of imprisonment for 5 years or more. 2. Any person who at any time has been sentenced to a term of imprisonment for 12 months or more within the last 10 years. 3. Any person who is subject to a period of prohibition on entry to New Zealand. Prohibition can arise if someone is deported from New Zealand. 4. Any person who at any time has been removed or deported from New Zealand or excluded from New Zealand under any law. And 5. Any person who has at any time been removed, excluded or deported from another country. Furthermore, Section 16 of the Immigration Act 2009 gives Immigration New Zealand a broad power to exclude someone from New Zealand where there is reason to believe the person is likely to commit an offence in New Zealand that is punishable by imprisonment, is or is likely to be a threat or risk to security, public order or the public interest, or is a member of a terrorist entity designated under the Terrorism Suppression Act 2002. We have seen situations where, although a person does not meet the listed criteria for exclusion in Section 15, Immigration New Zealand has applied Section 16 in order to deny a person a visa. Section 16 is quite broad, therefore, in that it can apply merely where there is reason to believe a person poses a risk. If a person falls into one of the categories at Section 15 or 16, they will need the grant of a special direction first before they can be granted a visa or entry permission. Although the Immigration Act states that special directions will be considered by the Minister of Immigration, in practice special directions are usually considered by a delegated decision maker, which is a senior Immigration New Zealand official. The official has absolute discretion as to whether they will grant the special direction. Having absolute discretion means the official does not have to give reasons for their decision, and in fact they are not required to consider the request for special direction if they consider it is not appropriate to do so. The concept of absolute discretion also applies in this context of Section 61 requests, which I have delivered a previous video blog about. If you are a person to whom Section 15 or 16 of the Immigration Act applies, you may very well need professional help to gain entry to New Zealand. At Laurent Law, we have much experience in preparing and filing special directions. We can work with people to help them explain their situation, to convince a decision maker that a special direction should be granted. Over time, we have met people who, while they cannot change the fact they have been convicted of a serious offence, for example, may have explanations that help to explain why the offending occurred, or they may have some significant connection to New Zealand which justifies why they should be granted a visa and entry permission even though they have a criminal conviction or convictions. Matters such as these need to be carefully discussed with the client and supporting evidence prepared and provided to Immigration New Zealand to give the request for special direction the best chance of success. Requests for special direction are made in writing. Therefore, whoever prepares and files the request needs a level of skill in written advocacy. We are proud to offer such service at Laurent Law. You may be interested to know that my principal, Simon Laurent, has previously written a blog article regarding the consequences of being excluded from another country, specifically Australia. Simon makes the point in his article that the New Zealand High Court, in a New Zealand High Court case, has demonstrated that a complete and total exclusion from another country is required in order for a person to be excluded from New Zealand. It is not enough that a person has had mere restrictions on the ability to enter another country placed on them. You can find Simon's blog on our website if you're interested to read more. If you believe you are excluded from New Zealand, or perhaps you have applied for a visa and subsequently been informed by Immigration New Zealand that you are excluded, then we can help. Please contact us for a consultation using the contact information on our website. Thank you for listening, and all the best.